This is Bindu Sharma from Origiin IP Solutions. Today we will talk about freedom to operate search. This is also called as patent infringement risk analysis or clearance search. The purpose of this search is to assess the risk of patent infringement before or at the time of new product launch. So before we proceed further, I will briefly explain you what is patent infringement. So if you see Indian Patent Act, there is no clear-cut definition of patent infringement, but the rights of patent holder, they are explained well in detail. So if you look at rights of patent holders, so once you obtain a patent, you have right to prevent third parties from making, using, offering for sale and importing the product in the territory where you have patent protection. This means that if you have an Indian patent, you can prevent everyone from making, using, offering for sale, selling or importing the patented product in the territory called India. Now, if you have to launch any product in India, it's important to assess how many patents are there in that particular country and then find out if you are likely to infringe any third party's IP rights or not. So this search is very important because this search at least tells you in advance what kind of risk you are taking by launching a new product. Okay, so typically freedom to operate search is done by segregating components of the product and then performing search for each component to pull the patents available for that particular patent. And once you have pulled all the patents, you have to categorize them into active patents, lapsed patents and expired patents. So because it is patent risk infringement analysis, you don't have to worry too much about the expired patents, but yes, the patents which are in force, they may be critical for you. So you have to see how you can prevent encroachment of those patent rights. So here what should be done is you should check the claims of the patent and then map those claims with your product features, and if there is any risk, if there is any overlap which is happening, then that means that there is some risk of infringement and you should avoid using those patents to make your final product. Now, assuming the fact that there are some patents which you are likely to infringe, then what are the bypass options? Because just talking about patent infringement is incomplete without me giving you the bypass options. All right. So I just take one example that I'm into a manufacturing of a water purifier and I come across a patent which talks about the water purification process. Now, how do I bypass infringing that particular patent? So I have a couple of options. First of all, I should check expiry of that patent. If that patent is going to expire in next 1 or 2 months, then it makes a lot of sense for me to wait for that patent to expire and then use my process to make my final product. Second option could be I can always talk to the patent holder and take permission or license to use that particular patent. And also this FTO search gives you a lot of clarity on the kind of risk you are taking. If you are likely to infringe any third party's patent, then if there is a risk, you should be able to analyze what kind of risk you are taking. So this way, the freedom to operate search helps not only to assess the infringement risk, but also to mitigate that risk and also to quantify the volume or the extent of risk that you are taking by manufacturing the product. So overall, if you see, patent infringement risk analysis should be done at the time of new product launch. But if you do this search right in the beginning, once you have finalized features of the product or the steps of the process that you are going to opt, then you can in advance take measures to prevent infringement of third parties' IP rights. I'll just give you one case study. There is a small company called as Vernetex, and FaceTime video feature of Apple phones. So Apple happened to infringe 4 patents of Vernetex by implementing this FaceTime video feature in their phones, and Vernetex filed a lawsuit against Apple, and Apple was supposed to pay to Vernetex $368 million as damages because Apple infringed 4 patents of Vernetex. So you should always avoid this kind of situation because this is not good for your business. And if you happen to infringe third parties' IP rights, then this may put your company, your reputation, your goodwill in a big trouble. So, patent infringement risk analysis, freedom to operate search, clearance search, these all are synonym terms which are used in the industry. And freedom to operate search is very important for you to perform in order to play safe in the market. Freedom to operate search should be done country-wise. If my product is to be launched in the territory of India, then I should be performing FTO search only for India jurisdiction. But if I have to export my product to the another jurisdictions like US and all, then I should be performing specific FTO search for that particular jurisdiction. Because every country grants its own patents, and validity of a patent is based on the country where it has been granted. So if India has granted a particular patent, then the FTO opinion has to be as per Indian laws. So interpretation of laws of a country is very, very important while imparting the FTO opinions, and preferably a person who is good in science and the person who is good in law is authorized to perform and give opinion on FTO search. And while doing FTO search, you have to pull the patents which are related to your products, and you should typically be looking at a timeline of around 22 years, because 20 years is term of a patent, and then sometimes it takes at least 18 months for a patent to be published. And if there are some international patents, like a US patent gets filed in the US first, then if they are going to file in India through PCT route, then the typical steps they adopt is filing in the US, then filing PCT application, then again filing in India. So sometimes this the whole cycle of filing patent may be signed to some 20-22 years. So it is safe to pull patents of last 22 years and then segregate them based on their status, legal status, like in-force patents, expired patents and lapsed patents, and then perform the FTO search. And it is always advisable to repeat your FTO search after every 6 months, at least for 3 to 4 times, because the patents that are lapsed today, they may come into force again tomorrow. Now, I will explain to you what is the difference between in-force patents, lapsed patents, abandoned patent applications, and also the expired patents. Now, in-force patent is the one which is active. Which is active means that is in force. Now, abandoned patent application is the one which has been abandoned by the patent office for 2 reasons. The first reason is that after filing provisional application, the complete application is not submitted. Because of that, patent office may abandon that patent application. The second reason for application to get abandoned is that when the patent office issued examination report, you have failed to reply to examination report within a given period of time. In that case, patent application gets abandoned. Now, coming to lapsed patent, after patent is granted, there is a specific period of time in which you have to pay the renewal fee. So if you don't pay renewal fee in time, then the status of your patent changes from in-force to lapsed patent. But here the best thing is the lapsed patent has one more chance, wherein the patent holder can pay the pending fees and bring the patent into force again. So these lapsed patents, you have to be always very, very careful about the lapsed patent, because sometimes the patent holder, he may consider lapsed patent as an expired patent, and tomorrow it may come into force again. So that's why I told you that every 6 months FTO search should be repeated. So lapsed patent has one more chance to come into force. Now, coming to expired patent. Expired patent is the one that has either lived life of 20 years or for any reason it is not going to come into force again. So expired patents are usually safe to use, but don't take this sentence as a legal opinion, because due diligence of each and every patent has to be done at the time when you actually want it to be done, and then interpretation of claims may vary. So expert legal advice should be taken every time whenever you are going to perform FTO search. Okay, so these are my general views, but from case to case basis you must perform the due diligence separately for each patent.